The Supreme Court's ruling on SB 8, the Texas abortion law, one of the strictest in the nation. In an 8-1 vote, the court ruled that abortion providers will be allowed to continue challenging the state's near total ban on abortions, but the law will stay in effect, at least temporarily. The decision, written by Justice Neil Gorsuch, deals with what many consider a temporary victory for civil rights groups challenging a law that denies women in Texas a right protected by the Constitution. Joining us now are ABC News senior national correspondent Terry Moran, ABC News senior Washington reporter Devin Dwyer, and professor at Florida State University College of Law Mary Ziegler. Thank you all for joining us here. Devin, let me start with you. Break down what we heard today in terms of what it means, not just for Texas, but in terms of precedent establishing national law.
Yeah, Kenneth, this was a significant development at the Supreme Court, disposing of two cases that were challenging SB 8, that Texas ban on abortions after 6 weeks of pregnancy, and with that unusual enforcement mechanism that deputizes everyday citizens to sue, to enforce the law, to seek that $10,000 bounty. Today, the Supreme Court dismissed a challenge by the Biden administration, didn't say much about that, but they did respond in a very fractured and complicated ruling to the case brought by Texas abortion providers. You hit the headline at the top. The court said, in the opinion by Justice Gorsuch, that a very narrowly tailored challenge to SB 8 can continue in federal courts. That was the good news for abortion advocates today. But it declined for a second time now to put SB 8 on hold. And that means that women in the nation's second most populous state will not be able to access most abortion services, certainly after 6 weeks of pregnancy, for the foreseeable future, despite the fact that the Supreme Court has still held with those 50 years of precedent that it's a constitutionally protected right. And just a few minutes ago, I was in a briefing by the lead attorney for those abortion providers who brought this case, challenging it, Mark Heron, who called this a dark day for abortion rights in Texas and for constitutional rights. He said that even if this very narrowly tailored challenge that was allowed today, if that is successful, he said that wouldn't be enough to allow abortions to resume in the state of Texas. So a significant development for abortion rights in Texas, and not a good day for those providers, Kenneth.
And Terry, of course, you normally anchor this hour for us here on ABC News Live. Thanks for letting me fill in for you. And you've covered the courts very closely over the years, and you've been following this one. I know you're going to have a report on World News tonight as well. Is this a victory for those that challenged the law implemented more than 3 months ago?
I don't see it as a victory for those people challenging the law, for the women of Texas, very much at all. Look, it's not as if the court, in this opinion by Justice Gorsuch, actually slammed the courthouse door on those seeking to vindicate their constitutional right still to choose to have an abortion. But there's not much of that door left open. So what the court did here is, because this Texas law, remember, is rather deviously designed, it's not government officials in the state of Texas who are stopping abortion. What this law does is it allows private citizens to sue people who help women get an abortion, potentially exposing them to ruinous expenses, legal expenses. And so that's a very clever device, because seeking redress for constitutional rights violations is generally a matter of saying, hey, you got to stop the governor, you got to stop the police, you've got to stop the state official from denying me my rights with these laws or these procedures that they're doing. Texas tried to evade that, tried to evade federal court scrutiny. That's why they designed the law this way, by having private citizens essentially enforce the law for the legislature. And the Supreme Court said, well, there's nothing we can really do about that, because we don't we don't stop every single possible private person who might want to interfere with this right. But, and here's where they left the door a little bit open, there are 4 people in Texas who work for the state government who issue executive licenses for medical personnel, for doctors and others. And they say, well, those people you can sue under our Constitution. What that basically means is that there's a tiny avenue to use the federal courts, which traditionally are the place that we all go to vindicate to our constitutional rights if the states are denying them. Justice Gorsuch and the other conservatives on this opinion, they basically said the only people that you can go to in the state of Texas are these 4 licensing officials. Will that be enough? Will that be enough to restore what is still the constitutional right of women to choose to have an abortion in Texas? It's hard to say how the district court, how a lower court would handle what the Supreme Court has told them to do. It's pretty clear that most of what Justice Gorsuch and the other conservatives are saying is, you're out of luck here.
And Mary, we know that the Supreme Court also dismissed a Biden administration request to stay enforcement of this abortion law. What stood out to you from today's ruling?
Well, I think what stood out to me, too, in addition to what this means for abortion rights, is how easy the court made it for other states to use this sort of SB 8 style law to get around other constitutional abortion rights. Because, of course, if you can avoid the enforcement of abortion rights by saying simply private citizens do the enforcing, state officials don't, there's no really saying that that's going to stop with abortion rights, regardless of what the Supreme Court has to say about Roe v. Wade in its upcoming decision on a Mississippi case this summer. And so the court really didn't do much in this ruling at all to shut down that possibility. If anything, as Terry was saying, the court focused on these 4 officials, in part because the law itself said that nothing in it prevented the state from enforcing other abortion laws, which the court took to mean state officials, these specific state officials, may still be enforcing the law. So if it hadn't been for that slip up by the state of Texas, the state could have just prevented any lawsuit from happening at all. And it won't be very hard for other states, whether liberal or conservative, to use that as a blueprint going forward to pass their own SB 8 style experiments when it comes to any of our constitutional rights, not just to the right to abortion.
Terry, I've watched your reporting on this Texas abortion law over the past few weeks, and I've heard the way you've described the writing of this law. I think you may have, and please forgive me if I misquote you here, but it was pretty clever. Some of the wording and the way that the enforcement is put into the hands of everyday citizens here and not the state, essentially, here. But I have to, and you touched on it a little bit moments ago, but I want to drill down on this and the fact that the justices appeared to be skeptical of the language used in this Texas law. So I have to ask you, why is it so important we really look at the language here?
Well, because, as I said, the language here, it does feel almost like a law school assignment from a professor saying, okay, figure out a way around federal court scrutiny if a state wants to deny a constitutional right. You know, like others, right? You can imagine a gun rights, a gun control state saying anyone who sells ammunition or a gun that is later used in a crime can be sued. And you know, boy, you'd shut down the gun market right away. And so the language in that law is designed in such a way, very, very cleverly, to prevent federal courts in their traditional way, a way that they've exercised for more than a century, to reach into state government operations in order to make sure that every citizen of the United States, even if they're in the state of Texas or Mississippi or New York or anywhere, has the full enjoyment of their federal constitutional rights. But the way they've done that is by preventing state government officials from enforcing state laws that would deny those rights. The most famous one, of course, is segregation, Jim Crow laws. The way those laws were overturned is that the Supreme Court of the United States, or lower courts after Brown versus Board, said you can no longer enforce the state law that divides children on the basis of race into different schools. You can't segregate the schools anymore because the U.S. Constitution prevents that. And so all you government officials who are doing that must stop. That's how we ended segregation in America. This law essentially is designed to make sure that there's no government official out there, except for that slip-up, as we pointed out. They included 4 government officials, and so those people can be enjoined. It is a devious and I would say cynical way of trying to evade our constitutional system. And in a ferocious dissent, Justice Sonia Sotomayor says this is an attempt to nullify the federal constitution by a state that doesn't like it. and she raises the specter of the people that led to the Civil War, John C. Calhoun and others, with their doctrine of nullification and interposition that would deny the federal government the opportunity to make sure everyone in every state has the full enjoyment of their federal civil rights. It really is a precedent that could go a long way if it maintains, what it looks like the Supreme Court has done today.
A lot at stake here. And Mary, walk us through the legal nuances that are now in play here. Well,
we're expecting that another important point, right, is that even if, in a best case scenario for abortion providers, even if this suit picks up again in the district court, and even if the district court says this law is clearly unconstitutional as the law currently stands, because Roe v. Wade and its successor case, Planned Parenthood versus Casey, they say there's a right to abortion until viability, which is well after this Texas ban kicks in. Even if that happens, we're not really looking at much of a reprieve for abortion rights in Texas or much of anywhere else, because the Supreme Court, of course, has another case in the pipeline, this Mississippi abortion case that prohibits the procedure after 15 weeks. And the Supreme Court, in hearing that case last week, seemed poised not only to hold that states could pass some bans on abortion for viability, which is, of course, what Texas's SB 8 is, they also seem poised to hold that there is no right to abortion at all. So even in if we sort of assume a kind of, I think, unrealistically optimistic scenario for abortion providers in the short term when it comes to this law, I think we're looking at a reality in which by probably the summer of 2022, Texas doesn't need to go to the lengths, these sort of stealth strategies that Terry was describing, to prohibit abortions in the state. The state can just criminalize the procedure outright. And that's quite likely what we're going to see. So it's also worth emphasizing that just outside of the particulars of SB 8, we're in a world where any kind of exercise of abortion rights in Texas is going to be short-lived.
All right, a lot still to watch and follow. A big thanks to you, Mary, Terry, and Devin. I appreciate it. Thank you.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.